A warm welcome to one and all present here. We are extremely happy, honored, and delighted to have Honorable Senior Advocate Pradeep Rai sir and his also wonderful associate. We are really privileged today for getting this opportunity to present the case TechnipSA versus SMS Holding Private Limited and others. The Honorable Judges bench consists of Justice C.K. Thakkar, Justice Ruma Pal, and Justice Arijit Pasayar. Now we'll advance with the facts of the case.
In this case, an appeal has been filed before the Supreme Court of India. The appellant, Technip, is a company incorporated in France, and the respondents are the shareholders of Southeast Asia Marine Engineering and Construction Limited, which is also known as CMAC. The company is registered in India and a subsidiary of CoFlexip, which controls the majority shareholding of the company through a chain of wholly owned subsidiaries. The appeal involves two other parties as well, the Institute Français du Pétrole and ISIS. ISIS is IFP's subsidiary through which IFP is a shareholder in Technip and CoFlexip. Technip has acquired control of CMAC through CoFlexip, and as per the Securities and Exchange Board of India 1997 concerning certain issues, some shareholders of CMAC filed a complaint against Technip before the Securities and Exchange Board of India under the SEBI Act 1992. Securities Appellate Tribunal, also referred as SAT, held that Indian law was applicable and the relevant date of control was 12 April 2000 and not July 2001. SAT therefore directed Technip to pay CMAC shareholders the difference between the price of the shares between July 2001 and April 2000 together with a 15% interest of such difference. The appellant thus has approached the Supreme Court of India now. The issues in the present cases were primarily about the following: the maintainability of the present appeal, if the applicable law would be French law where the appellants were incorporated, or Indian law, that is, where the respondent is registered, whether the appellant acquired control of the respondent through CoFlexip in April 2000 or in July 2001, the rate of interest 15%, the adjustment of dividend, and the identification of the shareholders.
Next, we'll begin with the proceedings of the court.
With the court's permission, we would like to proceed with our submission, Your Lordship. Permission granted. Much obliged, Your Lordship. Your Lordship, the humble submission of the counsel would be that Technip and CoFlex are both registered in France, and the takeover of CoFlex by Technip also took place in France. Hence, the applicable law is French. According to the French law, there was no control of CoFlex by Technip in April 2000, and as such, there was no charge in control of CMAC on that date but in July 2001.
Counsel, in regard to Regulation 12 of SEBI, whether the Technip, when acquired the CoFlex, whether company was knowing whether they were going to control it in future or not?
No, Your Lordship. In any event, Regulation 12 did not apply to the takeover because CMAC was not the target company. And while taking over CoFlex, Technip neither had the common objective nor was there any agreement between Technip and CoFlex with regard to CMAC. Your Lordship, moving further, the rate of interest has also been challenged. It is said that although there was no challenge to the rate which was fixed by SEBI, if the tribunal order is upheld, then the impact of interest would be much greater. In any event, the dividend paid must be adjusted against the interest claimed. Your Lordship, hereafter, we would like to conclude that if April 2000 is to be taken as the date of control, then only those shareholders who were shareholders of CMAC on the specified date and continued as such till the offer was made are entitled to the benefit of tribunal's order.
Your Lordship, with your permission, we would like to present our case. Your Lordship, the law applicable to CMAC was Indian law, and to determine if there was a change in the management and control of CMA. The provisions of regulations would apply. In terms of Regulation 10, 11 and 12, read with Regulation 2, any person who acquires share or voting rights in registered company here described as the target company under the regulation above 15% of or acquires control over the target company is required to make public announcement offering to purchase the share of the shareholders in the target company. Your Lordship, it is our submission that according to Indian and French law, de facto control of Coflexit and therefore CMEC was taken over by Technip in April 2000.
Council, have they acted in consonance with the SEBI regulations?
Your Lordship, we have applied to SEBI to exempt them from the operations of regulation. The application have been rejected. Therefore, this issue could not be reopened. CMEC was very much in contempt of Technip when it was decided to take over Coflexit. Therefore, we request that Regulation 10, 11 and 12 should be applied in full measure. We have not only acted in concert with ISIS, another shareholder of Coflexit, but even by ourselves we are in position to exercise and in fact exercised control over Coflexit and therefore CMEC in April 2000.
In addition to this, Your Lordship, we would like to highlight that the public offer made by Technip after SEBI's order was unconditional. It is made to the shareholders who were categorized so as on the date of the public offer. On the question of interest, it is to be said that it was not open to Technip to question either its liability to pay interest or to determine the rate of interest. It is to be noted that Technip had already paid interest to the present shareholders without protest. Hence, concluding the argument, Your Lordship, it is our humble request that the finding of the fact by the tribunal should not be interfered unless it is decided so by this court.
Your Lordship, a separate appeal has been preferred by IFF from the decision of the tribunal being CA number 10092/98. The grievance of IFP is that it is a professional body created by decree of the French government and has been set up as a center for research and industrial development, education, professional training and information for the oil and gas and automotive industries in France. IFP does not carry on any industry or commercial activities, nor does it manage or control any listed company. It promotes companies to apply the results of its own research. IFP says that an unnecessary stigma has been cast by the tribunal's decision on the government organization, even though the so-called notice issued by SEBI did not make any allegation against IFP. Thank you, my Lordship.
The court observed Section 15Z of the SEBI Act 1992, which provides for an aggrieved to file an appeal in any question of law arising out of the order of Securities Appellate Tribunal. The dispute regarding the application of either French law or Indian law to the transaction is undoubtedly a question of law. The issue relating to internal affairs of companies are to be resolved by applying the law of their domicile. However, SEBI concluded that Indian law would apply over Technip acquiring the control over Coflexit despite both the companies are being domiciled in France. But by that token, it is equally true that CMX, which was incorporated in India, would be governed by Indian law, that is what Securities Appellate Tribunal held. SEBI has no jurisdiction to regulate takeovers and acquisitions taking place outside India, but certainly it has the jurisdiction to regulate the substantial acquisitions and takeovers of companies in India.
After considering the affirmation rationally, the court has observed that the allegations of ISIS and Technip acting in consensus in the purchase of 29.68% shares in Coflexit had not been established presently. Furthermore, there are no evidences that Technip acquired Coflexip in April 2000 to gain the control of CMAC. Therefore, it is held that SEBI's order will be prevailed and the order of SAT will be set aside.
Consequent upon our decision to allow the appeal, the bank guarantees furnished by Technip to secure the differences in amounts between the share prices, which would be payable by Technip. Had SAT's view prevailed, must be are hereby discharged. The appeals for these reasons allowed without cause.
In this case, the main object for consideration was pertaining to the question law applicable, and when the applicant had assumed control over Coflexip to ascertain the amount payable to the shareholders. Considering the case of Aberdeen, Asia Pacific including Japan Equity Fund versus DCIT, the Bombay High Court had held that the status of an entity incorporated abroad had to be determined even in India according to the law of the country where the entity was incorporated. As provided by the judgment in the present case, to resolve a particular conflict, a court has to examine the text of the French law as translated, and along with the material on record has to determine the appropriate application of the said provisions. The Supreme Court, thus, in the landmark case of TechnipSA versus SMS Holding Private Limited and others, held that SEBI's order would prevail and the order of SAT was consequently set aside. As far as the remaining issues pertaining to the rate of interest, the adjustment of dividend and the identification of the shareholders of CMAC, the same would arise only if SAT's order has been upheld. That will be all from us. Thank you.
हर्षिता फोटो के लिए वेलकम एडिटिंग आप चले जाओ आगे चले जाओ जैसे वहाँ जिगर मिले ना